We're going to close tonight by taking a look at the 14th Amendment and the guarantee of birthright citizenship. And I want to do this for two reasons. First, the primary author of the 14th Amendment was an Ohioan, John Bingham, which I just think is a fact that you should know. It's pretty cool because Bingham's political views reflected what he saw at home, and that was a dramatic change in race relations at the time. Second, last week, the U.S. Supreme Court announced that next month it would take up a Trump administration claim that birthright citizenship does not apply to the children of migrants here illegally. So consider this a primer for what's likely to come and expect both sides to go back, way back, to make their arguments.
I think the case has been so misunderstood. That case, birthright citizenship, is about slavery. If you look at the details of it, the signings of it, everything else, that case is all about slavery.
At the heart of what the president is saying is a conservative argument. It gained prominence during the 1980s with the release of a book, Citizenship Without Consent. It argues in part that the enactors of the 14th Amendment had no frame of reference for illegal aliens when they debated the concept of birthright citizenship, that it simply guarantees citizenship rights for former slaves and their descendants. Debates over the amendment during the 39th Congress, however, challenged that view. Said Senator Edgar Cowan, conservative Republican who opposed the 14th Amendment, it would, quote, have the effect of naturalizing the children of Chinese and the slur for Romas born in this country. When replied, Senator Lyman Trumbull, a supporter who drafted the 13th Amendment about abolishing slavery, by the way, he replied, undoubtedly. No one contradicted Trumbull's view that birthright citizenship would apply to migrants in the country, and even the slavery argument cuts against the idea that lawmakers who debated the 14th Amendment did not take illegal immigration into account. That's because in many ways, some blacks not held in bondage were, in effect, illegal aliens, and some for the very same reasons that arguments were made concerning them that helped to shape the future debates over who could enter and stay in the country. Paul Finkelman is a professor of law at the University of Toledo College of Law. He is also a renowned expert on the 14th Amendment. He joins me now. Professor Finkelman, welcome to CTW.
It's a delight to be here.
I didn't miss anything, I hope.
Oh, you're good.
Okay. I think the argument from the authors of Citizenship Without Consent works this way. Congress did not regulate immigration prior to the 14th Amendment, so how could the enactors have any concept for shaping immigration policy? Why, in your view, is this an ahistorical viewpoint?
Well, for one thing, Congress had regulated immigration at least three different ways before the 14th Amendment. In the Alien Enemies Act, which, in fact, President Trump has tried to use to expel people from the United States, claiming that they are enemies, which is a kind of an odd concept since the Enemies Act refers to people during time of war. But the Alien Enemies Act allows for the expulsion of somebody from the United States on the grounds that they are the citizen of a country with which we are at war. If somebody was designated an enemy alien and told that person is told you must leave, and the person did not leave, which would be entirely possible because the United States was not organized the way it is today, it would be easy to simply slip out of town and move west and not be found for a while. That person would have been an illegal alien because they've been ordered to leave. But under the 14th Amendment, the children of that person born in the United States would be citizens of the United States because the language says, and I read from the Constitution, all persons born or naturalized in the United States are citizens of the United States, with the exception of the children of diplomats and Native Americans who are living in what is physically owned by the United States, but has not yet been settled or governed by the United States, or children of an invading army, of which there has not been one since the War of 1812.
I want to hone in on something here because the president seems to be focused on slavery. in making this argument. There's very little consideration that's been done here with respect to the presence of German immigrants, Catholics, and others who fought during the Civil War especially. Why was that so impactful at the time, and why would that have been at the presence of mind of the enactors of the 14th Amendment?
Well, because starting in the 1830s and running up to the Civil War, there are various political parties that are opposed to any kind of Catholic immigration, opposed to Irish immigration, sometimes opposed to German immigration. The most prominent is a party called the Know Nothing Party. And one of the planks of the Know Nothing Party is that no Catholic could ever hold public office in the United States. So there were plenty of examples of successful political parties. The Know Nothings captured a number of governorships. At one point, the Speaker of the House of Representatives was a Know Nothing. There were plenty of examples of political parties that were agitating to stop immigration altogether.
I wish I had much more time, Professor Finkelman, but the U.S. Supreme Court is going to take up this question May 14th. I want to have you back then so that we can talk more about this. Professor Paul Finkelman of the University of Toledo School of Law. Thank you, sir.